We have some breaking legal news, which is stunning, but not altogether unsurprising. As you know, Donald Trump has publicly ordered the prosecution of many of his political opponents, including former FBI Director James Comey. Well, earlier this morning, a federal judge humiliated the Trump administration and accused them of engaging in misconduct, which may have forever tainted the case such that it might get tossed out. But before we unpack all that, if you end up liking this video and you want to support the channel, please be sure to hit the like, subscribe, and alert bells before you go. Incompetence, weaponization, dishonesty. What else can we possibly expect from the Trump Justice Department? It's pretty shocking, and a federal judge was shocked earlier today. As Mediaite notes in the headline, judge rules Trump administration misconduct may have tainted the James Comey case in scathing order, and Politico does an even deeper dive. Judge says possible errors by Lindsay Halligan, which is the acting interim U.S. attorney for I think it's the Eastern District of Virginia, could imperil Comey case. In a rare move, the judge ordered prosecutors to hand over records of the grand jury proceeding to the former FBI director's lawyers. That's James Comey's lawyers. A federal magistrate judge says, quote, government misconduct may have tainted the criminal case against former FBI director James Comey, describing a cascade of apparent errors by lead prosecutor Lindsay Halligan. The magistrate judge, William Fitzpatrick, ordered prosecutors Monday to quickly turn over records of secret grand jury proceedings to defense attorneys as they seek to dismiss the false statement and obstruction of Congress charges pending against Comey in federal court in Alexandria, Virginia. Quote, the court recognizes this is an extraordinary remedy, Fitzpatrick wrote in a 24-page opinion. Quote, but given the factually based challenges the defense has raised to the government's conduct and the prospect that government misconduct may have tainted the grand jury proceedings, disclosure of grand jury materials under these unique circumstances is necessary. Fitzpatrick's decision came after he personally reviewed records of the grand jury proceedings that led to Comey's September 25th indictment on the charges that he lied to Congress in 2020. The indictment was signed by Halligan, Trump's handpicked prosecutor, who was installed by Attorney General Pam Bondi when other prosecutors resisted bringing the case against Comey. So again, as a reminder, Trump has for years, publicly and privately, wanted the Justice Department to prosecute James Comey. He wanted it in his first term as a candidate for office in 2024. He talked about prosecuting Comey again. This time, he has made good on his promise. He managed to get a case brought against Comey right before the statute of limitations expired. And in order to do it, he fired his own handpicked U.S. attorney nominee, Eric Siebert, because Siebert said, hey, listen, there's not a case to be brought here. I can't win. There's just not a good case to be brought. So even though Trump was the one who appointed Siebert, he was like, you're not MAGA enough. Get the hell out of here. Fired him and replaced him with former insurance attorney and personal attorney of his own, Lindsay Halligan. And then Lindsay Halligan secured a grand jury, indictment against James Comey, and the rest is history. This is political prosecution of the highest order, again, the likes of which we've simply not seen. And then Donald Trump has doubled down on it against Letitia James, the New York Attorney General, former National Security Advisor John Bolton, and others, okay? So keep all that in mind. This is the background for this. The magistrate judge's assessment adds to the mounting possibility that Comey's case will be dismissed before it goes to trial. In addition to the procedural flaws Fitzpatrick said appeared to occur, Halligan is facing a challenge to the validity of her appointment altogether and could be disqualified from the case. Fitzpatrick raised sharp doubts about an account of the grand jury proceedings provided by the Justice Department and whether it had turned over all records of the interactions between Halligan and the grand jurors. He noted that Halligan claimed she had her last contact with the grand jury at 4:28 p.m. that day while the jurors were deliberating. But he also noted that the grand jury initially rejected one of the counts against Comey, leading prosecutors to prepare a new indictment that Halligan ultimately signed. Yet nothing in the record reflects the grand jury's initial decision or consideration of the second indictment, Fitzpatrick said. Quote, the short time span between the moment the prosecutor learned that the grand jury rejected one count in the original indictment and the time the prosecutor appeared in court to return the second indictment could not have been sufficient to draft the second indictment, sign the second indictment, present it to the grand jury, provide legal instructions to the grand jury, and give them an opportunity to deliberate and render a decision on the new indictment, Fitzpatrick wrote. Fitzpatrick also said Halligan, who had never prosecuted a case prior to Comey's, appeared to make two, quote, fundamental misstatements of law to the grand jury that could jeopardize the indictment altogether. So again, she lied. Not good. Not good. He said Halligan, facing tough questions from grand jurors, appeared to suggest Comey might have to testify at trial to explain his innocence, an improper characterization of the government's burden to prove guilt beyond a reasonable doubt. Fitzpatrick also said Halligan appeared to improperly suggest grand jurors could assume the government had more evidence against Comey than what it presented to them. Like, hey, listen, remember, They're trying to secure an indictment, right? So they have to present the grand jury the evidence that they have. Here's why you should vote to indict this person. Here's the evidence we have against them. Here's the charge. Here's the evidence. And what she said was, listen, if you don't find this persuasive, just assume that we actually have more evidence than what we're prepared to show you. Stunning. Stunning that she would say this. Quote, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding, he wrote. U.S. District Judge Michael Nachmanoff, a Biden appointee overseeing the case against Comey, assigned Fitzpatrick last month to address some of the issues related to possible violations of attorney-client privilege. At a hearing earlier this month, Fitzpatrick ordered prosecutors to overturn all the grand jury transcript to the defense, but Nachmanoff told the magistrate judge to reconsider after prosecutors objected. Prosecutors could also appeal Fitzpatrick's latest decision to Nachmanoff. Spokespeople for Halligan and the Justice Department declined to comment. Fitzpatrick also expressed particular concern that Halligan's presentation relied entirely on the testimony of a single FBI agent who may have reviewed the materials subject to Comey's attorney-client privilege, with longtime associate Daniel Richman, a Columbia law professor who served as an official advisor to the FBI director. The FBI agent was made aware that he may have inadvertently reviewed the material improperly, Fitzpatrick said, but still, quote, proceeded into the grand jury undeterred and testified in support of the pending indictment. But the government's decision to allow an agent who was exposed to potentially privileged information to testify before a grand jury is highly irregular and a radical departure from past DOJ practice, the magistrate judge wrote. Fitzpatrick also said the agent may have reviewed materials that went beyond those the government had been authorized to examine. But the government appears to have inflated its obligation to protect privilege information, an obligation it approached casually at best in this case, with its duty to seize only those materials authorized by the court, wrote the magistrate judge, who slammed the government for its, quote, cavalier attitude toward the issue. Prosecutors routinely seek a search warrant when they want to use old evidence in a new investigation. But they did not do so in this instance, the judge said. He called the decision inexplicable, but also suggested that it stemmed from an unrelenting drive to beat a statute of limitations deadline to indict Comey that was set to run out last month. Remember, I mentioned at the beginning, they were scrambling. They're like, shit, this is it. We gotta get Comey. And if the statute of limitations runs out, then we can't even bring the charges. So that timeline to politically prosecute one of Trump's political opponents may have contributed immensely to this very situation. Prosecutors have argued in the event of the indictment against Comey is dismissed, a federal law effectively extends the statute of limitations for 6 months after that ruling or the resolution of any appeal. Comey's lawyers say the extension would not apply in these circumstances. So, we're going to look at reaction in just a moment. But Kyle Cheney, who was the author of that Politico article, he was like live tweeting at the same time. I'm just curious if he has anything here. Again, the magistrate judge said an FBI agent reviewed Comey's privileged materials. Was nevertheless permitted. Yeah, we talked about that. Eye emoji. Fitzpatrick said that Halligan made 2 fundamental misstatements of law to the grand jury to threaten the case. Ron Filipkowski responded to that. The court issued a scathing ruling today, the Comey chase. Fitzpatrick notes, among other things, that Halligan made 2 false statements of law when responding to questions by grand jurors. And Filipkowski, who's an attorney, said Halligan's law license is in serious jeopardy, looking to join a long list of disbarred and disciplined Trump attorneys. Oh, shit, that's not good, folks. That is not good. Quote, a disturbing pattern of profound investigative missteps. Not good. I'm curious how Twitter is reaction, so let's see what we can find. Virginia judge orders DOJ to release grand jury materials in Comey indictment. This is trending on Twitter. We have Kyle Cheney, Scott McFarlane, Ed Krasenstein, one of the Krasenstein brothers, Democratic pundits on Twitter, commenting on this. Curious if there's like any actual commentary. Adam Park-Benko says a federal judge sees enough smoke of government misconduct under Trump that they're forcing the DOJ to cough up grand jury materials to James Comey. These people didn't just break the rules, they set the rule book on fire, shoved it down a storm drain, and then lectured the rest of us about law and order. This isn't a justice system, it's a crime scene. Pretty harsh language. The irregularities in the grand jury proceedings may justify the dismissal of 1 or more counts of the 2-count indictment, the magistrate says. Let's see here. Conclusion, the court recognizes that the relief sought by the defense is rarely granted. However, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding. Therefore, in this case, quote, the court has before it a rare example of a criminal defendant who can actually make a particularized and factually based showing that grounds exist to support the proposition that irregularities may have occurred in the grand jury proceedings and may justify the dismissal of 1 or more counts of the indictment. That's not good. That, again, that's coming from the judge's ruling in specifically. Not good. There goes the Comey indictment. Didn't AG Bondi bless this? Isn't she also responsible for this flagrant violation? A troll Twitter account making fun of Trump says it's not government misconduct when the government does it. The jury system is an underappreciated check and balance on authoritarian power in the U.S. Constitution. Indeed, this is an order that will horrify any lawyer. When the judge tells you that she thinks you've misled the court and possibly acted improperly, your career's on the line. I believe it. The judge is male, but whatever. Pronoun notwithstanding. Yeah, not good. Aaron Parnas, Midas Touch legal contributor, says, I don't think people realize how big of a deal this is. Defendants almost never get access to grand jury testimony. All right, folks, it's stunning stuff. It really is. As Fox News lawyer Andrew McCarthy said, and he had no way of predicting this, but he expected that this case might be dismissed before it gets to trial. And it looks like because of incompetence and dishonesty and corruption for the Trump administration, it seems increasingly likely that that's the case. And I'll definitely be looking forward to his analysis on the matter. There you have it, folks. Let me know what you think in the comments.